Hi, this is Manjay Singh from Law School 101 and this is a video in the Legal Aptitude series brought to you by Law School 101 for CLAT aspirants. In this video, we will be covering criminal law. The topics to be covered in this video are theft, kidnap, sedition, homicide, and murder. Following this, questions from the previous year CLAT 2017, CLAT 2016, AILET 2017 and AILET 2016 papers will be discussed that are relevant to the above listed topics. Alright, let's begin. The first topic is theft. Whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. A thing, so long as it is attached to the earth not being movable property, is not the subject of theft, but it becomes capable of being the subject of theft as soon as it is severed from the earth. A moving effected by the same act which effects the severance may be a theft. A person is said to cause a thing to move by removing an obstacle which prevented it from moving or by separating it from any other thing, as well as by actually moving it. A person who by any means causes an animal to move is said to move that animal and to move everything which, in consequence of the motion so caused, is moved by that animal. The consent mentioned in the definition may be express or implied and may be given either by the person in possession or by any person having for that purpose authority, either express or implied. Now let's look at some illustrations. The first situation is A cuts down a tree on Z's ground with the intention of dishonestly taking the tree out of Z's possession without Z's consent. Here, as soon as A has severed the tree in order to such taking, he has committed theft. The second situation is A puts a bait for dogs in his pocket and thus induces Z's dog to follow it. Here, if A's intention be dishonestly to take the dog out of Z's possession without Z's consent, A has committed theft as soon as Z's dog has begun to follow A. The third situation is A meets a bullock carrying a box of treasure. He drives the bullock in a certain direction in order that he may dishonestly take the treasure. As soon as the bullock begins to move, A has committed theft of the treasure. The fourth situation is A, being Z's servant and entrusted by Z with the care of Z's plate, dishonestly runs away with the plate without Z's consent. A has committed theft. In the fifth situation, Z, going on a journey, entrusts his plate to A, the keeper of the warehouse, till Z shall return. A carries the plate to a goldsmith and sells it. Here, the plate was not in Z's possession. It could not therefore be taken out of Z's possession, and A has not committed theft, though he may have committed criminal breach of trust. Now, the next situation. A finds a ring belonging to Z on a table in the house which Z occupies. Here, the ring is in Z's possession, and if A dishonestly removes it, A commits theft. In the next situation, A finds a ring lying on the high road, not in possession of any person. A, by taking it, commits no theft, though he may commit criminal misappropriation of property. In the next situation, A sees a ring belonging to Z lying on the table in Z's house. Not venturing to misappropriate the ring immediately for fear of search and direction, A hides the ring in a place where it is highly improbable that it will ever be found by Z, with the intention of taking the ring from the hiding place and selling it when the loss is forgotten. Here, A, at the time of first moving the ring, commits theft. In the next situation, A delivers his watch to Z, a jeweler, to be regulated. Z carries it to his shop. A, not owing to the jeweler any debt for which the jeweler might lawfully detain the watch as a security, enters the shop openly, takes his watch by force out of Z's hand and carries it away. Here, A, though he may have committed criminal trespass and assault, has not committed theft, inasmuch as what he did was not done dishonestly. In the next situation, if A owes any money to Z for repairing the watch, and if Z retains the watch lawfully as a security for the debt, and A takes the watch out of Z's possession with the intention of depriving Z of the property as a security for his debt, he commits theft, inasmuch as he takes it dishonestly. In the next situation, if A, having pawned his watch to Z, takes it out of Z's possession without Z's consent, not having paid what he borrowed on the watch, he commits theft, though the watch is his own property inasmuch as he takes it dishonestly. In the next situation, A takes an article belonging to Z out of Z's possession without Z's consent with the intention of keeping it until he obtains money from Z as a reward for its restoration. Here, A takes dishonestly. A has therefore committed theft. In the next situation, A, being on friendly terms with Z, goes into Z's library in Z's absence and takes away a book without Z's express consent for the purpose merely of reading it and with the intention of returning it. Here, it is probable that A may have conceived that he had Z's implied consent to use Z's book. If this was A's impression, A has not committed theft. In the next situation, A asks charity from Z's wife. She gives A money, food, clothes, which A knows to belong to Z, her husband. Here, it is probable that A may conceive that Z's wife is authorized to give away alms. If this was A's impression, A has not committed theft. In the next situation, A is the paramour of Z's wife. She gives a valuable property which A knows to belong to her husband Z and to be such property as she has no authority from Z to give. If A takes the property dishonestly, he commits theft. In the last situation, A, in good faith, believing property belonging to Z to be A's own property, takes that property out of B's possession. Here, as A does not take dishonestly, he does not commit theft. The next topic is kidnapping. Kidnapping from lawful guardianship. Whoever takes or entices any minor under 16 years of age if a male, or under 18 years of age if a female, or any person of unsound mind out of the keeping of the lawful guardian of such minor or person of unsound mind without the consent of such guardian is said to kidnap such minor or person from lawful guardianship. The words lawful guardian in this section include any person lawfully entrusted with the care or custody of such minor or other person. This section does not extend to the act of any person who in good faith believes himself to be the father of an illegitimate child or who in good faith believes himself to be entitled to lawful custody of such child unless such act is committed for an immoral or unlawful purpose. Where the facts indicate that a girl left her father's protection knowing and having capacity to know the full import of what she was doing and voluntarily joined the accused, the offense of kidnapping cannot be said to made out. The next topic is sedition. Sedition is section 124A of the Indian Penal Code, which defines sedition as whoever, by words either spoken or written or by signs, visible representation or otherwise, brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life, to which fine may be added, or with the imprisonment which may extend to 3 years, to which fine may be added, or with fine. The expression disaffection includes disloyalty and all feelings of enmity. Commence expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offence under this section. Commence expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offence under this section. The next topic is culpable homicide. Section 299 of the Indian Penal Code defines culpable homicide. Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offence of culpable homicide. For example, A lays sticks and turf over a pit with the intention of thereby causing death or with the knowledge that death is likely to be thereby caused. Z, believing the ground to be firm, treads on it, falls in and is killed. A has committed the offence of culpable homicide. In the next situation, A knows Z to be behind a bush. B does not know it. A, intending to cause or knowing it to be likely to cause Z's death, induces B to fire at the bush. B fires and kills Z. Here, B may be guilty of no offense, but A has committed the offense of culpable homicide. In the third situation, A, by shooting at a fowl with the intent to kill and steal it, kills B, who is behind a bush, A not knowing that he was there. Here, although A was doing an unlawful act, he was not guilty of culpable homicide, as he did not intend to kill B or to cause death by doing an act that he knew was likely to cause death. A person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity and thereby accelerates the death of that other shall be deemed to have caused his death. Where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. The causing of the death of the child in the mother's womb is not homicide, but it may amount to culpable homicide to cause the death of a living child if any part of that child has been brought forth, though the child may not have breathed or been completely born. The next topic is murder. Section 300 of the Indian Penal Code defines murder. Except in the cases hereinafter accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death, or if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of a person to whom the harm is caused, or if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Now let us look at some situations. Number 1. A shoots Z with the intention of killing him. Z dies in consequence. A commits murder. In the second situation, A, knowing that Z is laboring under such a disease that a blow is likely to cause his death, strikes him with the intention of causing bodily injury. Z dies in consequence of the blow. A is guilty of murder, although the blow might not have been sufficient in the ordinary course of nature to cause the death of a person in a sound state of health, but if A, not knowing that Z is laboring under any disease, gives him such a blow as would not in the ordinary course of nature kill a person in a sound state of health, here A, although he may intend to cause bodily injury, is not guilty of murder if he did not intend to cause death or such bodily injury as in the ordinary course of nature would cause death. In the next situation, A intentionally gives Z a sword cut or a club wound sufficient to cause the death of a man in the ordinary course of nature. Z dies in consequence. Here, A is guilty of murder, although he may not have intended to cause Z's death. In the next situation, A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. A is guilty of murder, although he may not have a premeditated design to kill any particular individual. When culpable homicide is not murder, if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of a person who gave the provocation or causes the death of any other person by mistake or accident. This is an exception which is subject to the following provisions. The provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. Provocation is not given by anything done in obedience to the law or by a public servant in the lawful exercise of the powers of such public servant. Provocation is not given by anything done in the lawful exercise of the right of private defense. Whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact. Let us look at some situations. Number 1. A, under the influence of passion excited by a sudden provocation given by Z, intentionally kills Y, Z's child. This is murder inasmuch as the provocation was not given by the child and the death of the child was not caused by accident or misfortune in doing an act caused by the provocation. In the second situation, Y gives grave and sudden provocation to A. A, on this provocation, fires a pistol at Y neither intending nor knowing himself to be likely to kill Z who is near him but out of sight. A kills Z. Here, A has not committed murder but merely culpable homicide. In the next situation, A is lawfully arrested by Z, a bailiff. A is excited to sudden and violent passion by the arrest and kills Z. This is murder inasmuch as the provocation was given by a thing done by a public servant in the exercise of his powers. In the next situation, A appears to witness before Z, a magistrate. Z says that he does not believe a word of A's deposition, and that A has perjured himself. A is moved to sudden passion by these words and kills Z. This is murder. In the next situation, A attempts to pull Z's nose. Z, in the exercise of the right of private defense, lays hold of A to prevent him from doing so. A is moved to sudden and violent passion in consequence and kills Z. This is murder inasmuch as the provocation was given by a thing done in exercise of the right of private defense. In the next situation, Z strikes B. B is, by the provocation, excited to violent rage. A bystander intending to take advantage of B's rage and to cause him to kill Z, puts a knife in B's hand for that purpose. B kills Z with the knife. Here, B may have only committed culpable homicide, but A is guilty of murder. Culpable homicide is not murder if the offender in the exercise in good faith of the right to private defense of person or property exceeds the power given to him by law and causes the death of the person against whom he is exercising such right of defense without premeditation and without any intention of doing more harm than is necessary for the purpose of such defense. Let us look at some situations. Z attempts to horsewhip A, not in such a manner as to cause grievous hurt to A. A draws out a pistol. Z persists in the assault. A, believing in good faith that he can by no other means prevent himself from being horsewhipped, shoots Z dead. A has not committed murder but only culpable homicide. Culpable homicide is also not murder if the offender, being a public servant or aiding a public servant acting for the advancement of public justice, exceeds the powers given to him by law and causes death by doing an act which he, in good faith, believes to be lawful and necessary for the due discharge of his duty as a public servant without ill will towards the person whose death is caused. Culpable homicide is not murder also if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel and without the offender having taken undue advantage or acted in a cruel or unusual manner. In this, it is immaterial in such cases which party offers the provocation or commits the first assault. The next exception is, culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with his own consent. For example, A by instigation voluntarily causes Z, a person under 18 years, to commit suicide. Here, on account of Z's youth, he was incapable of giving consent to his own death. A has therefore abetted murder. Now, we will move on to the previous year questions starting with CLAT 2017. Here is the principle. Whoever takes away with him any minor less than 16 years of age if a male or less than 18 years of age if a female out of the custody of parents of such minor without the consent of such parents is said to commit no offense. Facts. A man took away a girl below 16 years to Mumbai without informing the parents of the girl. The answer options are: number 1, A committed no offense against the parents of the girl. Number 2, A committed no offense against the girl as well as her parents. Number 3, A committed an offense against the girl as well as her parents. And number 4, A committed an offense against the girl. The correct answer is option 2. The trick in the question is to read the principle as it is. Although we recognize that the principle gives us the definition of kidnapping, the principle defines the offense as no offense. Therefore, kidnapping is equal to no offense. Hence, we will have to take it as no offense. A has committed kidnapping by looking at the fact situation. By replacing it with no offense, we can derive the answer as to option 2. There were no questions in the AILET 2017 paper relating to these topics specifically, so we move on to CLAT 2016 questions. The first one is principle. Whoever takes away any movable thing from the land of any person without that person's consent, he is said to have committed theft. Facts. During his visit to the house of C, A asked B, the son of C, to accompany A to the forest. Neither A nor B informed C in this regard. B accompanied A to the forest. Your answer options are: Number 1. A has committed theft as soon as he entered the house of C. Number 2. A has not committed theft. Number 3. A has committed theft. And number 4. A has not committed theft till B did not accompany him. The correct option is option 2. The principle refers to movable things, that is, an inanimate object or an animal. The principle here does not refer to a person. In the fact situation, only a person has moved from C's land, and that does not constitute theft. The next question. Principle. Killing is not murder if the offender, whilst deprived of the power of self-control by intense and sudden provocation, causes the death of the person who gave the provocation. Facts. A man found his girlfriend sleeping in her own bedroom with another man named B. A did not do anything but went to his home, picked a gun and cartridges, returned to the girlfriend's bedroom with loaded gun but found the place empty. After 15 days, he saw his girlfriend dining in the restaurant. Without waiting for even a second, A fired 5 bullets at his girlfriend, who died on the spot. Your answer options are: Number 1. A could have killed B instead of his girlfriend. Number 2. A could have killed both B and his girlfriend. Number 3. A did not kill his girlfriend under intense and sudden provocation. And number 4. A killed his girlfriend under intense and sudden provocation. The correct answer choice is option 3. You can eliminate 1 and 2 because these give you possibilities and not answer options. Grave and sudden provocation needs to be immediate. In this case, a cool-off period of 15 days has elapsed. Therefore, the provocation is not sudden and A cannot use his defense. A famous case, at the crux of which lay the sudden provocation issue, is the K.M. Nanavati vs. State of Maharashtra case of 1961. It was also the last case to be decided by the jury, after which juries were abolished in India. There were no questions in the AILET 2016 paper relating to these topics specifically. So, thank you for watching this video. For more resources, follow, like and share our page Law School 101 on Facebook. Subscribe to our main YouTube channel by the same name. We encourage you to post your doubts, queries and questions in the comment section below. These will be replied to within reasonable time. Best of luck, law aspirants.